really quick before you do, just to announce, I am going to record Dallas's presentation, just to let you guys know, not that it should make too much difference, but I did want to just make sure that you're aware that it's being recorded.
Far out. Okay, let me get this up. Are you seeing that when I bring it up? It's never done it like it is right now.
No,
What
it's
is
not.
the Zoom curse?
I know they upgraded,
Uh,
but I think those upgrades have harmed all their normal functions.
yeah,
Every single presenter has had issues today, so I've now said it is officially not us at Zoom.
okay, I'm gonna wing it here a little bit and see how it goes.
Yes, then just from beginning and
Sweet.
you can see it.
Is that still good before I dive in?
Yep, that looks perfect.
Okay. All right, sweet. Well, I think we can skip past this lovely title screen and get into the real meat and potatoes of it. So before I talk specifically about applying for Utah's program and getting benefits, I wanted to give some general information on reparations. So the idea that victims should be helped with out-of-pocket expenses resulting from their victimization is actually a relatively recent idea. So California was the first state to start a kind of reparations program, and then other states followed suit. So now every US state and territory does have its own reparations program. And while there are some differences between them, they do serve the same basic purpose. And there are actually some things that are pretty unique and cool about Utah's program, I think. So I will bring those up as I get to them. So assuming that somebody has a approved claim for the Office for Victims of Crime, we can pay up to $25,000 per primary victim, so the person who was directly victimized. And if they have medical expenses exceeding the $25,000, we can pay up to $50,000 specifically for medical. And I also think it's important to have some idea of where this funding is actually coming from. So we do get general funds through the state of Utah, which is a quarterly payout. And this is a fairly recent change. What used to be the bulk of our funding were fines and penalties paid on citations and criminal charges. But that has changed. And the nice thing about it is it's now a more predictable revenue flow. And that's allowed us to expand some benefits, which I will talk about when they come up. We do also collect money in the form of restitution and subrogation. So the basic idea behind restitution is that if you commit a crime against somebody and they have expenses resulting from it, you should theoretically pay that money back to them. And since we pay out money on behalf of victims, we can also seek restitution. And subrogation is the same idea, but it involves a third party. So this would be like an auto insurance, for example, paying out on a DUI incident. And we also do get some funding through the Victims of Crime Act, usually referred to as VOCA. So we do have both state and federal funding. And then I like to bring up the question first of who should be applying for Utah's program? Because a lot of times the assumption is that it's for Utah residents, but what determines it the vast majority of the time is where the crime took place. So if I live in Boise, Idaho, and I get assaulted while I'm on a business trip in Salt Lake City, I would apply to Utah's program because that's where the crime took place. So we are still able to help with services for people in other states and in a more limited capacity to people in other countries as well. That can be more difficult, but we will do that when possible. So a couple of exceptions as far as where the crime took place. So if you're a Utah resident and you are the victim somewhere that does not have a comparable reparations program, which most countries do not, then you would apply in Utah. So if, for example, I go to Guatemala and get assaulted there, Guatemala doesn't have a program, so I can get services in Utah. And segue to something I see in the chat. Oh, it's just a affirmative. Okay, I will go on. So the other exception beyond happening in a country without a reparations program is if you're victimized somewhere that can't be said to fall into any specific state or territory. So most common example of this that we see are cruise ships. Since they're in international waters, you can't say that it took place in X state or territory, so you would apply wherever you were a resident of. Um, a nice thing about Utah is that immigration status does not impact eligibility. It's one of the few conservative states where that's the case. If someone is undocumented, it's not something we're going to know unless they actually disclose that to us. And another thing that's nice about Utah that isn't generally true is there's not a filing limit. A lot of states you have to apply within X number of days or weeks after the crime was committed. But Utah, it just has to be a crime that took place on or after January 1st, 1987. And the significance of that date is that's when the office was founded. And statutorily, we can't provide reparations for crimes that happened before the office existed. So now that I've given you some general information, I want to talk a little bit about what are the crimes that we're actually working with, because I guess Utah Office for Victims of Crime is a snappier name than Utah Office for Chapter 5 offenses in the Utah Criminal Code, but that is really what we are providing services for. Also, so I will try to be more conscious of our interpreter here. I realize I can speak pretty quickly. So I wanted to talk about the types of crimes that we are actually able to provide services for. They are these Chapter 5 offenses, which are mostly violent crimes. So any type of physical assault, whether it's simple or aggravated, any type of child abuse, whether it's physical or sexual, DUIs with injury or death, elder abuse, home invasions, homicide, kidnapping, human trafficking, and that can be sex trafficking or labor trafficking. And then any type of sex crime running the gamut in charge severity from sexual battery on the low end to aggravated rape on the high end, any sex crime qualifies. And then threats of violence, stalking, protective order violations, as well as similar crimes. So that could be like a pretrial no contact order violation, for example. And then we have vehicular assault or vehicular homicide. And then bigamy is the most recent Chapter 5 offense. So if somebody has been one of multiple spouses in a bigamous marriage, that is now considered a Chapter 5 offense, and they can also receive services. So just a couple of crimes people will ask about that we are not able to provide reparations for. One would be financial crimes, so like identity theft, fraud, stolen credit card, anything in that arena. And then property crimes, so like if somebody vandalizes your vehicle, for example. And then most vehicle crimes do not qualify. So one would be hit and runs. And I know this is one that we've talked about trying to change to be able to cover them. The issue with hit and runs is that intent is kind of a gray area, but we will see how that plays out over time. And then also like a stolen vehicle, for example, wouldn't be something that we could help with. But something I think is important to make clear is if you're working with somebody that's been a victim of a non-qualifying crime, that doesn't mean they wouldn't benefit from contacting us. So we do have an advocacy center here with full-time advocates and currently a couple of stellar interns who I see in here. And what they're able to help people with is, if the person's situation makes sense, helping them apply. But if not, kind of helping to connect them with other resources. So maybe this isn't something that's going to work in your situation, but maybe we can find something else that would be useful to you. Okay, So now I'm going to talk about the very kind of basic skeletal process of applying for reparations, and then I will start fleshing those steps out. So the first step is just the person applying should fill out an application, and I will have a copy of that in a couple of slides. We do need a signed and dated application. And then our next step would be, as an agency, requesting a police report. Now, a caveat here, which I'll get to, this has slightly changed as of the passing of a recent law, but for the most part, we do still need crimes to be reported to law enforcement, but I will touch more on that. So once we review that report, we determine basic eligibility. So does it qualify? If so, what does it qualify for? And then we inform the applicant of that decision. The default way to do that is us sending a letter, but if people request otherwise, we will do so. Some people would prefer email contact or just to touch bases with us, especially if they're living with the abuser. They don't want to be getting mail from us, most likely. Okay, so moving on to additional steps. So assuming we've approved the claim, the benefits that we pay will either be paid to service providers or directly to the applicant or victim, and I will break that down a little bit down the road. And something else that's really important is everything we pay does need to be directly crime related. So an example of this would be if somebody punches me in the face and knocks one of my teeth out and I go to get dental work done, the Office for Victims of Crime can help me replace that tooth. But if I have, say, an unrelated cavity that I get filled at the same time, that wouldn't be coverable as it's unrelated to the assault. So we don't provide general assistance. It's specific to crime-related losses, injuries, and the like. Once somebody applies, those claims are active for 3 years, in which time they can continue to request benefits. People can request those to be reopened, and we can do so on a case-by-case basis. We can usually do that if they have unused mental health therapy, but it can get more difficult for other benefit requests. So if somebody's requesting relocation, for example, 5 years after the fact, it can be difficult for us to establish how that's a safety need related to the crime that amount of time later. But those can always be reviewed upon request. And going back to our victim advocates, if a claim is denied, and I'll talk about some of the different reasons why that might be the case, the claimants can speak to one of our victim advocates because they do have a legal right to appeal a denial if they wish to do so. Okay, I'm going to move on so you can actually see a copy of our application. You may have to squint depending on your technological scenario. And I'm not going to go over this exhaustively point by point because a lot of it is so straightforward, but there are a couple of things I will point out. So I mentioned earlier, it's if people want to indicate that they want to be contacted or not contacted in a certain way, this first section that asks for name and basic information is the best place to do it. So things like, again, email contact only or whatever it might be. The second section, this is asking all of the same basic information. This would just be used in 3 scenarios. One would be parent of a child victim, so they would apply on their behalf. Second situation would be somebody applying on behalf of the victim of a homicide, who obviously can't apply for themselves. And the third situation would be if the victim is an adult that's incapacitated or developmentally delayed in a way where they cannot apply on their own behalf, then a parent or guardian would do it. The third section that asks for insurance information. So this is very important. I can't stress this enough. Whether or not somebody has health insurance does not impact our ability to pay, but we do need to verify this to make payment. So we're coded in Utah law as what's called a payer of last resort. So basically what that means is that if there's another collateral source in place, it should be used before the Office for Victims of Crime makes payment. And the most common collateral source is health insurance. Now, that being said, people can request case by case to not have their insurance billed for one reason or another. So some of the most common situations where we see that and we'll waive it is first scenario. I have insurance, but I've been seeing the same therapist for 5 years and I don't want to change therapists and they're not paneled with my insurance. So we can approve a waiver to be billed directly to not disrupt continuity of care. We also get it sometimes on the basis of language and distance. So it could be the only in-network therapist is 80 miles away, and that's not practical for me. It could also be I need to see a Portuguese speaking therapist, but the closest in-network one is 200 miles away. And another common situation for waiving going through health insurance is an adult under 26 years of age who is on their parents' insurance and doesn't want their parents to know they've been sexually assaulted or whatever it might be. So again, that's the most common collateral source, but the other ones would be workers' compensation. If somebody has qualified for workers' compensation, those funds would be used before the Office for Victims of Crime. And the other situation would be an auto insurance payout. So if somebody's the victim of a DUI and receives a payout from their insurance and or the offender's insurance, they would need to exhaust those funds before we would come into play as a payer. The next two sections ask for crime and offender information. So depending on the nature of the crime, like it could be an assault by a stranger, they may or may not have all of this information on hand. The best things we can get would be a law enforcement agency and case number, because with that, we can usually track down a police report, but especially where people can apply for crimes going back to 1987, the more information, the better. And before the next slide, I'm going to take a sip of water. Okay, so moving on to the second page, we do need to be informed if there is a civil suit against the offender, because that would also play into the collateral source requirement if they received a payout. If you ever refer somebody as a victim advocate, I always ask if you would put your agency contact information. The reason for this is that, especially with transient victims and cases involving intimate partner violence, the contact information we have can become obsolete really quickly. And a lot of times the way we've been able to let people know they have benefits available to them is by contacting a agency that's had more recent contact who might have an updated address or phone number. The next section asks for benefits they're requesting. What I recommend here is for you to mark anything you know they need help with and anything they might reasonably need help with down the road. So let's say I had my nose broken and had to go to the hospital. Obviously, I'm going to need medical care. Maybe I haven't gone to court or anything yet. I haven't had to miss work, but that could well be a possibility. So I would mark that as well. That being said, if something isn't marked initially, no, you don't need to reapply or anything like that. It's just a matter of contacting us and saying, hey, I had to miss work to go to court. Can I also request lost wages? And that's a perfectly acceptable way to do that. So our applications do need to be signed and dated, and I like to let people read this at their leisure, of course, but also explain basically what these three sections mean. Assignment of recovery, the first one, this relates to what I had mentioned with restitution and subrogation. So this is the applicant acknowledging that if the offender in this case is charged and we pay out money, we will try to get a restitution order from them to pay that money back to us. Or in the case of, say, a DUI case, if there's an auto insurance payout, and let's say we pay money, but then there ends up being a payout, we will try to get that money back through the insurance payout. The second thing that they're signing to is just a basic release of information. Inevitably, we're needing to contact medical providers and others using the victim's information. So that's them giving us permission to do so. And the last thing is just a declaration of truthfulness that everything they submit is true and accurate to the best of their knowledge. I don't like to overemphasize it, but we have had some people send in misleading information that has led to convictions of fraud against the Victims Fund. So we do need to have that on there. Again, it's the vast, vast minority of the time, but it has happened, and they can be prosecuted if they submit false information. Okay, I will go ahead and move on. And I gotta say, I got good news for you. If you don't have a rip-roaring weekend read picked out yet, our statute and rule is available for free online right now. Okay, if nothing else, it's very informative as to what are we actually looking at to make the decisions that we're making, because we're not just making arbitrary decisions. It is very much based in statute and rule. So just kind of an idea of what are we actually looking at when we are deciding if something qualifies, and if so, what it qualifies for. So let's say somebody has applied and we have requested and received the police report related to the incident they're applying on. First, we need to see, was a crime committed? You have situations, for example, like so-called verbal domestics, or maybe things get heated and police are called, but it's determined that there wasn't actually a crime committed. But then there may be a crime committed, but it's not a qualifying crime. So we need to see, is it an approvable offense? So if we get a report for a stolen vehicle, for example, we would have to deny it as not qualifying. Then something else that's very important is the person applying as a victim, in fact, considered the victim in the case? That may sound obvious, but we do, in fact, get somewhat regularly applications from offenders, which is often baffling, but it does happen. If somebody's considered the offender in the case, they're not going to qualify. But where it's also important is we're not able to cover witnesses. So if I'm looking out of my bedroom window and see somebody get assaulted, that could certainly be a traumatic secondary experience, but it's not something where I would be able to qualify and receive reparations. An exception to that would be, for example, if a child witnesses intimate partner violence between their parents, or if they see a sibling being abused, for example, we are able to add them to claims as primary victims. The last situation where it's important to be considered a victim is you do have so-called mutual combat cases. So the idea here is that rather than a victim offender dynamic, you have two people that knowingly enter a fight. Typically in these cases, neither party is charged. And if it's considered mutual combat, then it's not something where they're going to be able to qualify for reparations. So now I'm going to start out when we're looking at cooperation with the caveat that this is a little bit different as of May 4th of this year, which I will elaborate on in the next slide. So if somebody is applying for reparations, they do need to be a so-called cooperative victim. So this would be providing the information necessary to law enforcement to conduct an investigation and submit it for charges to be filed if they get enough information to do so. So an important distinction there is that whether or not charges are filed does not impact our ability to pay out. So let's say the offender is deceased when it's reported, or they're not able to file charges because of evidentiary issues unrelated to cooperation. That in and of itself is not going to stop somebody from qualifying. Now, what would stop them from qualifying is if, for example, they specifically requested that charges not be filed against the offender, or let's say they are subpoenaed to appear in court and they don't, and charges are dismissed on that basis. So if we've paid out on the claim up until that happens, they don't have to pay that money back to us, but we wouldn't be able to make any payments going forward. And I should also say that if somebody initially doesn't want to cooperate but changes their mind down the road, if their claim has been denied, they can then ask for a reconsideration at that point to see if we are able to approve it. Now, all of that being said, as of a bill that went into effect on May 4th of, you know what, I've been saying this year, I am not used to being in 2023. It went into effect May 4th of last year. So this is now different for cases involving sexual violence or interpersonal non-fatal strangulation. So I'm going to talk about the effects of House Bill 228, which I think everybody in this field is in agreement has been a good thing. So as of May 4th of this year, victims of sexual violence don't need to report to law enforcement if they want to get benefits through our office. And if they do report, they don't have to follow up with prosecution. And it's not like a limited approval thing. They can qualify this way for any benefit that they would otherwise that's approvable if they had been cooperating. So we just need a victim advocate as spelled out in the different codes there to complete an adult sexual assault ability questionnaire. And I will have a copy of that in the next slide. And so long as it has the information that we need to approve it, then we can do so. And it spells out those definitions of a victim advocate because sometimes people will be helping a friend, for example, and say something like, I'm this person's advocate, but they're not actually legally a victim advocate. So it does need to be a victim advocate who works for an agency whose primary purpose is providing victim services. So this could be like a police agency victim advocate, a court advocate, rape recovery center advocate, a DV shelter advocate, or domestic violence, in case you're not don't know all the terms. I don't know all of your background, so I'll try to avoid jargon as much as possible. And beyond the sexual violence, this has also gone into effect for victims of interpersonal non-fatal strangulation. So the reason for that wording is that it expands it beyond intimate partner violence and could also include, for example, an adult child who strangles a parent, just to give a made-up scenario. So in this situation, we can get one of two things to approve them. And we haven't seen as many of these cases as we have with sexual violence. But one example would be a police report. And that would be whether or not they followed up with law enforcement. If they report to police that they were strangled, we can approve their claim. And the other thing would be medical records that corroborated the strangulation if they seek medical care immediately following being strangled. Now, immediately has the interesting effect of seeming really specific while not really being so. So talking to experts on this as far as what will immediately mean as far as documenting the effects of strangulation, it will likely depend on the severity of it. But the last ballpark guess I heard was in about 3 to 5 days is when they would need to go for strangulation symptoms to be able to be documented. And like with sexual violence, they can qualify for anything that's approvable. So the part about this that's kind of disappointing, but it's just the nature of statutory changes. It's not an internal decision, is that it does not apply retroactively. So if, for example, somebody applied in June of 2020 for a sexual assault case and didn't pursue an investigation, we would not be able to retroactively approve that. But to be clear, the important thing isn't when the crime happened, it's when somebody applies. So somebody now can apply for a crime that happened before May 4th, 2022. We just can't approve claims that were received before that date, if that makes sense. Okay, so now I'm going to have a copy of the adult sexual assault questionnaire that the victim advocates would be filling out. Like with our regular application, I'm not going to go over it point by point exhaustively because a lot of it's very straightforward, but I would like to emphasize a couple of points. So for location of offense and date of offense, we need at least an approximate version of these because we need to be able to establish, one, did it take place in Utah? And two, did it take place on or after January 1st, 1987? So we at least need a general idea of, in crime location, if it's Lehigh without an address, that's sufficient for what we need on this. And then it's going to have some questions like, is the suspect known to the victim? Did the victim report to law enforcement? Was the offender charged? So as far as if they reported to law enforcement and if the offender was charged, whether or not that's the case isn't going to impact eligibility, as I've just described. But if there is a criminal case resulting from it, then we do want to follow up on that to see about getting restitution from the offender if we do pay out money. Then we need at least a general description of the crime that took place. It's helpful to list any injuries stemming from it. And this goes back to what I said about everything we pay needs to be crime related. So if somebody is applying for medical expenses and we don't have any description of injuries, it may be difficult for us to get the information we need to pay something out. So as much information as you have and can provide is helpful. And we do need the advocate's name, signature for the form to be dated, and contact information. So that is that form. We've had it in place for, I guess, about 8 months now, and we've been able to provide services to a lot of people that wouldn't have been able to get them before the statutory change. And that's one of the things I mentioned, where we now receive general funds and have a predictable funding source that allowed us to make the case for, yes, this is something that is sustainable and will allow us to reach a population that we haven't been able to before. Okay, now I'm going to talk very briefly about our child victim eligibility questionnaire. I won't go over this one exhaustively. One, it's largely similar to the one I just described, which is for adults. And two, it's only filled out by law enforcement and DCFS caseworkers. But the reason we have this form is that in order to approve someone for reparations, we need some type of investigative report showing that was a crime committed and giving us the information we need to make a decision. And we have a right to get those police reports. But when a child victim is interviewed, their interviews specifically have a higher level of document protection than police reports do generally, and they do not need to release those to us. So we were in between a rock and a hard place, where on the one hand, we needed these interviews to corroborate a crime taking place, but on the other hand, they did not need to release those to us. So what we put into effect several years ago was this eligibility questionnaire for child victims, which can be for child physical abuse or sexual abuse, where they give us the general nature of the disclosure of abuse, the perpetrator, when and where it took place, and we can use that narrative to approve benefits for the child victim, even if we're not able to get a copy of the investigative report. Okay, now I will go on to the next slide. So I've talked a lot about approved claims, and then I want to talk about what are some reasons where somebody might get denied. So one would be, I've already talked about non-cooperation. And like I said, if somebody doesn't cooperate initially, if they do decide to pursue an investigation down the road, they may then be able to get approved at that point. Then we have so-called contributory conduct or misconduct. So another cool Utah thing, Utah was the first state to put into writing that nobody can contribute to being sexually assaulted. So nobody would ever get denied for contributing to a sexual assault. So normally we see this in assault cases, where it tends to be words or gestures of provocation. So this could be something like, and believe it or not, this does happen, like going up to a stranger and flipping them off and yelling at them and saying, "Come on, hit me, hit me." And then if that person does in fact get punched and applies, they will likely get denied for contributing to their injury, because there's no reason to think they would have been the victim of a crime if they hadn't engaged in inappropriate behavior. Another one that comes up is it's just not a qualifying incident. I gave the example of, if somebody's the victim of identity fraud or has a vehicle stolen, that can certainly be devastating to them, but it's not something that falls within those Chapter 5 offenses that we're able to provide benefits for. And inadequate information as a denial reason sounds frustratingly vague, but a lot of times that's exactly the problem. So these are situations where, for one reason or another, we don't have the information we need to determine eligibility. So we might have, for example, two people who both have injuries and a different account of what took place with no independent witnesses, and law enforcement isn't able to determine who's the victim and who's the aggressor, so they don't file charges. Obviously, that's a hypothetical scenario, but that's one where this might come up. Sometimes we'll see it where somebody may have some kind of mental illness, where they'll say that they were in their hospital room and somebody came in the middle of the night and assaulted them, but they have 24-hour camera monitoring and can show definitively that nobody had entered that room. So those are some scenarios where this comes up where, again, we cannot determine if this qualifies for reparations because of a lack of information as far as the crime that took place, who the perpetrator and who the victim is, or different reasons that might fall under that general idea. Okay, I'm going to move on now and talk about what are the benefits that we actually pay and how do we pay them logistically. So first, I'm going to talk about the benefits that we have generally falling within the medical category. So as I mentioned before, we are a payer of last resort. So if somebody has health insurance, that should be billed first, and then we should be billed as a secondary payer. Though, like I said, there are reasons where somebody can request a waiver, like if they've already been seeing the same therapist for a long time and that therapist isn't in network. That does have to be requested case by case and approved. There's no guarantee that a waiver will be granted in different scenarios. So yeah, we will be billed directly after person's health insurance, or if they have workers' compensation, we need to verify that they went through that and would only be able to pay what workers' compensation was not able to. So starting with the medical benefit, so the medical costs don't have a specific cap except for the overall claim cap, so $25,000, or if it's an aggravated case and they specifically have medical exceeding that, $50,000. And these costs ideally are just billed to us directly. We work a lot like a health insurance company does in the way that we process medical payments. And if you're working with somebody, I would really encourage them not to pay costs out of pocket. It is much easier for us to be billed directly than it is to work through reimbursement. So I'll just talk about this briefly to stress the importance of it. So one, there's been a law passed that if a provider has a pending invoice with us or somebody with a claim, they cannot send that bill to collections. And if they do, we inform them that no, you can't do that. And what they do is then pull it out of collections and bill it directly to us. And another thing, which is nice, is that we pay a discounted rate to providers, which they have to accept as payment in full as per state law. But the problem is if a victim pays out of pocket and doesn't have health insurance, we're also only able to reimburse them at that discounted rate. So what we try to do in those cases when it comes up is pay the provider our discounted rate to then have them reimburse the victim in full. And I hope it goes without saying that this is all much more difficult and takes much longer than if we're just billed directly. So if you're working with somebody and they're getting bills at home, I would encourage them to call the number on the bill, let them know they're working with the Utah Office for Victims of Crime, and to bill us directly. So most major providers are going to know who we are because they've worked with us extensively. But if they're working with, say, a therapist or a small provider who's not aware with our practices, I would just encourage them to reach out and ask about billing us. Moving on to mental health therapy. So we can pay up to 25 therapy sessions or $2,500, whichever comes first, for primary victims, which in my experience is almost always 25 therapy sessions, because we do pay at a discounted rate of $70 or $90, depending on the licensing of a therapist. And then for secondary victims, so this would be, for example, parent, sibling, spouse of a primary victim, we can pay up to 15 therapy hours or $1,250, whichever comes first. On this one, sometimes it is that $1,250 that comes first. It does have to be a licensed therapist. That's very important. We do look in Doppel to make sure they are licensed therapy providers. And we can cover med management. So let's say somebody after the crime is diagnosed with depression and is being prescribed antidepressants. But in order to cover med management, we have to confirm that they're getting that concurrently with the therapy that we're covering. So if they're just receiving med management, or if it falls outside of the number of sessions we're able to pay, then that's not something we're able to cover in that scenario. The dental benefit, like medical, doesn't have a specific dollar cap, so long as it doesn't exceed the benefit totals on the claim. And what we need in these cases is a pre-authorization from the dental provider. So this is letting us know this is the work that needs to be done. This is why this is the best option as far as what they're doing to repair the damage. This is what it's going to cost. And what we then do is review and approve those pre-authorization forms for a certain amount so that all parties are in agreement before the work is done. Sometimes if people get the work done before applying to our program, we can then review that information afterwards, but there's no guarantee of payment. So it's much better to get a pre-authorization so that nobody's stuck with something they can't pay, and you don't have a provider expecting payment that's not going to be able to get it. Okay, so now talking about other benefits. So we have our relocation benefit. So if a victim is displaced because of a crime or put in danger because of it, we can pay up to $1,000 for them to relocate. So this is most commonly in the form of a security deposit, and we can pay that directly to a landlord if we get a relocation form that we have filled out and a copy of a lease agreement. And we can also cover moving expenses. So that would be like renting a U-Haul, buying boxes and packaging supplies, for example. Now, these costs, I should say, we generally have to reimburse just because companies like U-Haul typically aren't willing to work with us because they don't know how long the person's going to have the van or whatever it might be for, and don't really have a way of pre-billing an amount. And then, so we're not able to cover rent costs, but our advocacy center that I mentioned before, they do have an emergency funds grant where they can sometimes help with relocation, like first month's rent, but that is case by case and there's no guarantee of that, but that can be requested situationally. Then if somebody doesn't feel safe but doesn't necessarily want to relocate, we do have our security benefit where we can pay up to $1,500, where we can cover the equipment and installation costs of security systems. And this is another one where we can pay it directly to a company or we can reimburse a victim. Just important to note that if they're going through a company that charges a monthly fee to monitor the cameras, we're not able to cover the monitoring costs. We can cover a medically necessary device. So this could be either something that they already have that's broken during the crime, like if my glasses are broken, for example, or it could be a device that you didn't need before, but now need to because of the criminal incident. So for example, we had a case where somebody on a motorcycle was sideswiped by a semi and it severed their right leg, and they then needed a wheelchair, which obviously they didn't need before. And in this case, we're able to pay up to $5,000 for these. And we can also cover a service dog under this benefit if we get a prescription from a medical or mental health provider indicating they need a service dog because of effects of the crime. Okay, some other benefits. For lost wages, we can pay up to 12 weeks at 2/3 of gross income missed. So this can be paid because of injuries. So my arm was broken and I'm a bricklayer, so I physically cannot work. But something again that's cool about Utah that I've realized is not generally true is it can also be for mental health reasons. So, for example, I have PTSD because of the crime, and I'm unable to work because of that. We do need that documented if they're missing it for medical or mental health reasons, but a lot of states are limited to paying for things physically preventing somebody from working. And beyond injuries, we can pay lost wages for things like people needing to attend court or crime-related therapy. For our funeral benefit, this is one we can pay directly to a funeral home, or we can reimburse to a like a claimant, the family member of the victim who applied. So this is up to $7,000, and it's pretty broad what we were able to cover under this. So beyond obvious things like the casket, burial, urn, it will also cover things like flowers and death certificates. Then we have our mileage reimbursement benefit. So if somebody is, for example, they're having to drive to follow up with a detective, they're meeting with a prosecutor because of the case, they're attending court, they might be going to crime-related therapy. They can fill out a form requesting mileage reimbursement for this, which we can pay to them so long as we have supporting documentation for the different dates. Just a couple of benefits we don't cover would be legal fees, schooling costs, and personal property. So, like if your coffee maker is broken, for example, by the offender, that's not something we would be able to cover. The exception to that being a medically necessary device. And also, if somebody like kicks in your door or breaks a window that somebody would be able to use to gain access into the home, that's another property damage cost we can cost, but only if it, or that we can pay, but only if it creates a security concern for the home. Okay, so now I'm going to talk about our sexual assault forensic exams. So if somebody is sexually assaulted, they can choose to have a sexual assault forensic exam. Usually, at least with adult victims, they only do these within about 72 hours of the assault, but there are different reasons why they might do it after that time frame. So this involves, for example, doing different swabs and various medical services. So they might be testing for STIs, for example, checking for injuries. And this is something that we are able to pay the providers for directly. So beyond the initial exam, we can do a follow-up exam. There used to be a time limit of 4 weeks in which we could cover follow-up exams, but we did get rid of that. So there's no longer a date restriction on that. And what will happen is a lot of times they will wait a week or two to test for certain STIs because they don't necessarily show up immediately after the assault. And another Go Utah moment is I learned that it's one of the few states that will pay for HIV preventative medication, which is good because it's extraordinarily expensive. It's a few $1,000s, as I understand it. They don't usually prescribe it because it is actually fairly harmful to the body. But if they think somebody's at high risk of contracting HIV, they will. So something that's important to note about this, most of the time with sexual assault forensic exams, even if the victim has insurance, we are just billed directly. So the reasoning behind that is these are typically performed by nonprofit agencies that are using the hospital facility but don't actually work for the hospital. So as nonprofit agencies, they just bill UOVC directly. Now, there are several, I think mostly rural hospitals that actually do have sexual assault nurse examiners on their staff. In those cases, the victim goes through the normal intake process, like they would for any other reason to go to the hospital. And in those cases, the hospitals will bill insurance unless the victim requests and receives a waiver to not have their insurance billed. And we do have claims specific to the sexual assault forensic exam. So these are completely separate from all the other benefits that I just talked about. So on that note, I'm going to bring up the application we receive for the Code R exams, which we get directly from the service providers. These are not filled out by the victim. This is another one I won't go over exhaustively because it's very straightforward, but you'll see here, this lists a law enforcement case number. If we don't have that, like in this sample application, we just need somebody to sign, like an on-staff physician or victim advocate, to indicate that, yes, in fact, this exam was conducted, and then this is sent in to us. Okay, I am now going to move on to restitution recovery. So this is one of our funding sources. When we pay out money and the offender is convicted, we will try and get an order for them to pay that money back to us. So I have some figures here that show we've really beefed up our restitution collection, where you see I have an age range where in those fiscal years we collected a little over $500,000 a year on average. Then fiscal year 2021, it was just under $1.3 million in restitution and subrogation. So again, subrogation would be involving a third party, so like auto insurance payout or a civil suit, for example. But then the important thing too is that victims can also request restitution from the offender for out-of-pocket expenses they had that we weren't able to cover. So let's say we have the following scenario where somebody punches me in the face and breaks my nose and a tooth, and Office for Victims of Crime pays out $5,000. But let's say I also had a $1,000 iPhone that was broken, which the Office for Victims of Crime is not able to pay for. So UOVC can try to get an order for that $5,000, but the victim separately can try and get a restitution order for $1,000. And if and when payments are made from the offender, the victim will receive that money before we do as an agency. Another quick drink of water. And what I would say with you as victim service providers, when working with victims, even if you don't know all the mechanics of restitution collection, I would just bring up, have you talked to the prosecutor about restitution? Because education is always getting better and people are always trying to do better. But I've talked to people in the past that after all the court proceedings have gone through have said something like, I wish I had known it was even a possibility. It was something that never came up. But victims do have a legal right to seek restitution, which is different from a legal right to receive restitution. There's no guarantee that payment will actually be made, but they can try and do that. And I think people need to be responsible and help them try and get the restitution that they deserve. Okay, so talking a little bit more about restitution recovery, I do think it's important to note that, yes, as an agency, we want to get that money back that we have paid out, but not at the expense of compromising the victim's safety. So what we will send out to the courts when we make a payment is a very basic form showing a benefit category and a payment made. So it could say like medical $5,000, for example, but it doesn't include specific service providers or specific services provided. Obviously, with relocation information, we're not going to list their address or where they moved to. And if it does come to the point where if we need to send more detailed information to the court, that is heavily redacted so that none of the victim's personal information that might be damaging to them is going to get into the hands of the offender. And we have had a couple of situations where with what they were wanting us to release for restitution recovery, we have decided we would rather eat the cost than send out what they were requesting of us because we didn't want to compromise the victim's safety or privacy. Okay, I have reached the end of the presentation. I just now realized some of this contact information is obsolete because I just recently moved positions and Sham Ray is no longer with the office. So if you want to superimpose my name over the phone number listed for her, that is how you can currently reach me. But I do have the same email address. I'm very receptive to questions by phone or email. But that being said, we do have about 5 minutes. So now is the time for questions, comments, or witty anecdotes.
What about Rick?